All right, hi, welcome back, Attorney Steve Vondran. Welcome to another exciting episode of Litigation Whiteboard. All right, this is a video I've been wanting to do. I said if I ever have some free time, which is hardly ever, I am going to do a video on civil extortion. And why? That's because people always ask me, what is this? Like, we defend a lot of people that are accused of infringement. So a lot of people say, how can they do that? This is legal extortion, or is this civil extortion? Is this extortion? Can they do that? Without further ado, let's head to the Attorney Steve Litigation Whiteboard. All right, here we are. So I wanted to talk about civil extortion in the context of California law, okay? We're licensed in California and Arizona. Your laws may differ in your states, okay? But I suspect there's something close to this. So this is not legal advice or a substitute for legal advice. But let's take a look. Let me get my, what are we going to do? Let's get my red pen out here. Now, most people I should say, are familiar with the term blackmail. You're blackmailing me. You can't do that. It's against the law. Okay, so this is what we're talking about in the area of civil extortion. Be thinking about like blackmail, okay? But let's take a look at it now. Blackmail, civil extortion is both a civil tort and can be a basis for a criminal prosecution, okay? So not only can you be sued for the tort of civil extortion, you can also go to jail, do some hard time as they call it. This is under the California Penal Code, PC, Penal Code 518. No, I don't do criminal law, but I just wanted you to know if you want to check it out. The definitions, as I put here, basically the same, okay? And that is obtaining property by wrongful use of force or fear. Obtaining property by wrongful use of force or fear. Do you see that? These are your key definitions. There's some other mumbo jumbo in there, but that's the heart of it, in my opinion. Obtaining property by wrongful use of force and fear. So there's also attempted extortion. If you didn't complete it, but you said, I want $50,000 or I'm going to expose your deepest, darkest secrets, and you didn't do it, that could be attempted criminal extortion. Now, let's take a look at the civil tort. A tort is a civil wrong one person commits against the other. That can lead to damages, which can lead to a lawsuit, which can lead to you paying punitive damages designed to punish and deter. So let's take a look at the elements here. We need a threat. We need a threat to do harm. Okay, that can come in things like in the business context that we see today. You know, if you don't give me $5,000, I'm going to blast it out and call you out for your fraud on Yelp. This is a big one we always see. I'm going to call you a fraudster on Yelp. Well, be careful what you're wishing for and what you're actually threatening, because you are threatening to do harm to them, harm to a company. That can be harm to reputation, harm to their person. I'm gonna, cut your arm off if you don't give me $1 million. Things like that. So a threat. We need a threat to do harm. I got some examples up here. Pay me $5,000 or I'm going to show those photos I have. You know which ones. Things like that. Threatening to do harm. Ransomware. This is another one. How many of you know about ransomware? This is actually a real deal, where your computer gets hacked, the files get encrypted, and somebody says, if you don't pay me $10,000 by Friday, I'm going to delete all your files. And that's a real deal. That's really happening. Ransomware is a form of blackmail. That's probably more of the criminal type, because now you're doing harm to like a whole business and threatening to put their whole business out of business. So a Yelp review, as I put here, immigration. If you don't settle this case, I'm going to report you to immigration. Things like that. So there's a million examples. We could go over these all day, but it requires this right here, the threat to do harm and a demand for money or value. There has to be that demand. Okay, anybody can have some right of free speech, but it's the demanding the money that's the big deal. Okay, and this is very important. You have to give in. The victim has to give in. The plaintiff has to give in. You have to actually pay the money. If you don't actually complete and pay the money, you can't have the civil tort. You may have attempted extortion, but if you don't give in, you don't have the civil tort, okay? And now, the reason I'm doing this, people always ask about lawyers, and they say, well, What about lawyers? I got them right here. You say, well, that's what they do. They send these demand letters and they ask me for $10,000, for this, that, or the other. Well, if there's a good faith grounds for what they're doing, I mean, lawyers have litigation privileges. We have the right to send demand letters out to seek recovery for our clients. So that's, some people call it legal extortion, okay? But it doesn't fit the crime of force and fear and things like that, threats to do harm. And lawyers have a privilege to fight for their clients within reason, within good faith, okay? What else? What can you get for damages? I have it right here. Return of your money. If you paid $10,000, you get your money back, and you might be able to recover punitive damages. Punitive damages, I have a video on that. Damages designed to punish and deter the wrongdoer so they don't do it again. And now that could be a significant award, okay? That it could be up to a jury to say, the jury's sense of outrage. That could $2 million for that, for doing that to that company. That's how bad it is. So you have those kinds of things. Punitive damages in California anyway, under the California Civil Code, Section 3294. 3294, like I said, I have a video on that. Check it out on my channel, AttorneySteveVideos.com. What else? Truth is not a defense. So say somebody says, well, you're firing me and I'm going to report you to a software compliance entity, telling them all the illegal software you're using unless you pay me $50,000. So here we are. That may be true. They may be using unlicensed software. Okay, we defend a lot of those cases, unlicensed software compliance cases. But again, if you have the threat, the demand for value, and an employer that felt no need, I had to give in, then you may have the civil tort of extortion. So truth, not a defense, like it is in defamation. There has to be the demand for money. We talked about that. And finally, some people will say, do you need a police report? No, you don't need to file a police report to have the tort. So you don't have to call the cops and get the cops involved and do all that stuff. But that's a general overview, general information only of civil extortion in California. Check your state, but you have both civil, you have criminal, you have the demands for money, and you have the potential for punitive damage. Now, be careful. A lot of these people that do these kinds of things are what we call judgment proof. Means they don't really have money. They don't have assets. They don't have a home with, $400,000 equity. They're sometimes not those types of people. You know what I mean? So you may be able to go get a judgment, but you may not be able to enforce it as attorneys. We always want to know, can we get a judgment that is enforceable? Can we garnish wages? Do they have a job? Do they have property that you can levy? Do they have money in the bank account? Those are some common things that you're looking for to make sure that you have a judgment. If you're going to spend all this time, make sure you have a judgment that's actually enforceable, okay? General legal information only. Hope you liked it. Hope that clarifies civil extortion versus blackmail versus legal extortion. And I've been wanting to do that video for a while, so there you have it. Have a great day. Got to run. Make sure to like, subscribe. If you got any comments, leave them below. But just don't leave me any threats. Okay now? Bye.